Good afternoon.
Okay, good morning, everyone. Can people connected online hear us properly?
Yes, yes, perfectly.
Perfect. Great. Good morning. My name is Emanuele Sommario, and together with Professor Chiti, Professor Palombella, Professor Capone, and Professor Pirni, I'm one of the organizers of this event. Let me first of all welcome all those who are here in presence. We really appreciate it, given the current circumstances, that you took the time and effort to be with us in peace. But obviously our thanks also go out to all those who are connected over WebEx and also over YouTube, because you know that this event is being streamed live over the internet. I will be very brief because I only have a ceremonial function, so to say. My function is to, again, express my thankfulness and the thankfulness of all the organizers to all of those who contributed to this event, and also to emphasize how much we, again, appreciate the fact that you responded to our appeal to come and speak about this very important issue. We are very sorry, of course, for all the restrictions which we have to endure, wearing masks and so on and so forth. But we think it's somehow it's the way in which we cope with a big, huge phenomena, and which in a certain sense also shows our resilience. And I think that this word resilience will also pop up in many of the contributions that we will be listening to today and tomorrow morning, because this is the key word, if you wish, in terms of how we all should react to climate change. I don't want to waste more of your time. I'm simply going to give you two technical directions which concern those mostly who will be speaking to us via the internet. So you will be able to either intervene directly or write your questions in the chat. and we will be able to read them. For those of you who are following via YouTube, you will be able to write your questions in the chat below the main video, and some of us will be monitoring that chat and then refer the questions to the chair. Before we start with our first panel, however, I'd like to thank and welcome Professor Gaetana Morgante, who is full professor of criminal law here at the Scuola and is also the director of the Dear Policy Institute, which is the institute under whose coordination this event is organized. And Gaetana will briefly address us to welcome us on behalf of the Institute and of the Scuola. So, Gaetana, you have the floor, please.
Thanks indeed, Emanuele. Can you hear me? Okay. So welcome to the Scuola Superiore Sant'Anna. It's a special pleasure, really, a special pleasure for me in my role of director of the Dear Policy Institute to open this important international workshop. Right from the title, this workshop reveals its ambitious goals to present and discuss the many and different changes of the traditionally mentioned in singular climate change. Among these changes, there are legal, ethical, political implications related to a different way to approach the regulation, the litigation, the sanctioning, the responsibility under both legal and ethical rules. In this meaning, the climate changes, in plural, studies are a key research area for the Dear Policy Institute and the Scuola. And this for many reasons. The strong interdisciplinarity of the topics able to connect different sciences, from social sciences to the so-called hard sciences. The capacity of climate changes studies to combine theory and praxis, thoughts and actions, scientific studies and public engagement. And finally, the ability of climate changes studies and actions to commit us to all the three different but at the same time crucial university missions. The first, the scientific research, the second, the education, and the third mission, namely to open the universities to the socioeconomic context, impacting on it through the knowledge transfer and the enhancement of knowledge. Let me finally special thank the colleagues and friends for their intensive work over the past months. In strict alphabetic order, Roberto Buizza, Francesca Capone, Edoardo Chiti, Gianluigi Palombella, Alberto Pirni, and Emanuele Sommario. A special thank also to all the speakers and the participants. I'm really confident that after these 2 intensive days of discussions and studies, our transversal research area on climate changes and environment will be enriched by new and important contributions, enlarging, why not, the teaching and learning community of the Scuola actually working on these important topics. So thanks indeed, and let me leave the floor to the colleague Roberto Buizza for his introductory remarks. Thanks.
Thank you. Thank you, Gaetana.
Thanks indeed to you.
Can you hear me? Yes. Just a few words to explain why Roberto is not an academic doing humanities is amongst us today. One of the things we always do when we start an article, jurists or philosophers or whoever starts writing on climate change, is to make reference to the actual facts, to the data, right? Every article starts with a brief introduction, and we thought that we do have at the Scuola one of the leading experts in climate change in Italy, with Professor Roberto Buizza, was joined the Scuola a few years back with a special mission to start a research train on climate change. So we thought that it was wise and appropriate to invite him to have a quick talk on the most recent data on climate change, and more specifically on the recent report by the IPCC on climate change. So this is why we invited him, and this is why we thank him very much for having accepted our invitation. And the floor is yours, Roberto.
Okay, thank you very much. Thank you for the invitation. It's great to be here. I'm very sorry if I will not be able to follow the meeting because I'm at the previous engagements, which are going to start in 23 minutes. So I will try to be quick in my brief introduction to the problem and to try to leave a couple of minutes, 2 or 3 minutes for questions, okay? So the climate challenge and the latest IPCC report. I want to start with a few images, not because I want to shock you with what's happening, but because I think we need to realize that as the climate warms, the frequency of the extremes and the intensity of the extremes continues to increase. The extremes are what are going to have a major impact on society, on people, on assets. So it's not really a global warming of 1 degree or 2 degrees on average, which is causing the big problems. The problems is that associated with such a warming, you have an increased frequency of extremes, of extreme events like droughts that can cause fires, like these images from what was happening in the Mediterranean this summer, okay? So this year, we had about 2.5 times the annual average of the period 2008-2020. And if you search the web and you look at about similar statistics for the US, for Canada, for other parts of the world, it's similar. The number of extreme events is going up. And it's not just that because the climate is getting warmer, that we are going to have more extreme heat waves and so high probability of fires, but we can also have high probability of flooding. Why is that? Because a warmer atmosphere can hold more water vapor. A warmer atmosphere is a more energetic atmosphere. So when you have phenomena like intense precipitations, because the system is more energetic, because there is more water vapor in the atmosphere, everything can be more extreme. And here are the floods in New Orleans, this in August. No, this was Hurricane Ida. And then we had similar episodes in Europe, in Belgium and in Germany. Okay, so first point is, it's the extremes who are hitting us and the world. So even if we are talking about global mean temperature rising by 1 degree, 2 degrees, which seems a small number, actually what it means is that these extreme events, which are causing damages, are getting more frequent. Why is that happening? Because we keep pumping CO2 in the atmosphere. The graph on the left is the latest observation from Mauna Loa, a very renowned observatory of CO2 in the Hawaii. So we passed 400 parts per million in 2015. 400 parts per million has never been observed over the Earth in the past 2.5 million years ago. So it's 2.5 million years that the concentration of CO2 in the atmosphere has been below that value. We are now at 420 and rising. And the other bad news is, if you look on the right-hand side, is that we are accelerating the amount of CO2 we are putting into the atmosphere. The percentage increase in CO2 goes up every decade. No? We grow economically, more countries are growing, population grows. As a result, if we are not going to decouple economic growth from the use of fossil fuels, we will keep pumping more and more CO2 and more and faster into the atmosphere. And net result is a warming. 2020 was the warmest year since 1979. The other point I would like to make looking at this map is that the global warming on average is 1.2 degrees today compared to 1900. But if you look at some specific areas, it is higher than that, okay? So we are at 1.2 degree warming compared to 1900. These are, for example, 5 reconstructions of the past climate done by 5 renowned institutes that and have been generated by looking at observations and using your system models, which are essential to understand what's happening in the atmosphere. So this is where we are, 1.2 degree warming, here. And if we continue along this trajectory, and this is one of the graph which is often shown, IPCC reminded us this, and this graph comes from the Copernicus Climate Change Service, a great source of information about climate change. If we continue with emissions as we're doing, we will reach the 1.5 degree, which was one of the targets which was discussed at the COP21 in Paris by 2034. Okay. Now, one of the new points. So this IPCC report of August 2021 more or less confirms what we knew already. Okay, it's based on 7 more years of data, so it's an update. It essentially says we humans are responsible. The warming keeps increasing, it increases faster, CO2 concentration keep growing, and so on. But there were a couple of points that were made in that report, which I think are very useful to understand what we can do and how fast we have to act. The first point is this the fact that there is this quasi-linear relationship between CO2 emissions and temperature warming, T prime, okay? So they clearly state in this summary for policymakers, which I invite you all to download from the IPCC website and read it, that there is this quasi-linear relationship. And indeed, this is what I did a couple of days ago to check whether this is the case or not. And I downloaded data from the Copernicus website of the warming, and I downloaded data about CO2 emission from a World Bank database. And if you look at how these graphs align, from 1980 to today, you can see that there is this quasi-linear relationship. So as we pump more CO2, we grow roughly linearly, okay? And indeed IPCC summary for policymaker talks about it, and it shows this graph, which is very useful to understand why we need to act and where we will end up if we do nothing. So the point that we make is that if we add another 1,000 gigatons of CO2 into the atmosphere, we will warm the atmosphere by about 0.45 degrees. So 1,000 gigatons, how big is this number? Well, in 2019, we injected into the atmosphere 45 gigatons, okay? So say 50. So 1,000 gigatons in 20 years. If we continue like that, if we don't decrease the numbers, we will reach 1,000 gigatons in 20 years. So in 20 years, we will have a further warming of 0.45 degrees, okay? And this is a conservative estimation, because if we keep in mind that actually the economies are growing, we will probably keep increasing the percentage increase in CO2. So for sure, in 20 years, we will add another 0.45. If we want to keep global warming below 2 degrees, which is again another COP21 Paris Agreement limit that the people said we would want to try to not to overcome, we cannot put more than 1,800 gigatons. So we have about 40 years of time, okay? In 40 years, we will be above that. So we will not pass 2 degrees in 2100. We will be at 2-degree warming in 2060, roughly. What you see in this graph is a projection of where we could be by 2050, which is the end of these different shaded trapezoidal forms, depending on different assumptions on economic growth and emission of CO2. So the first two, the two that would keep us below 2 degrees, assumes that we will not put more than 1,800 gigatons. How can we do that? We can do it only by decreasing substantially the emissions year on year and reaching zero net emissions by 2050, okay? The other 3 scenarios are scenarios where we don't manage to do it and we will go up to 2.5, maybe 3 degrees. How can we reduce future emission? Well, I want to talk about Italy since we are in Italy. Maybe you know, maybe you don't. We are still producing 9% of the electricity in Italy using coal. Coal is the most CO2 emitting source of energy. Okay, here on this little table, I'm showing you how many grams of CO2 equivalent you emit per kilowatt hour of electricity production. Coal 1,200, gas 500. Look at wind, hydro, and solar, how small they are. So in Italy, 9% of electricity is produced using coal. We should, for example, in Italy, switch this off, and make sure that we add another 10% production using wind, hydro, solar. And immediately we can get a very big, a substantial reduction in emission. Okay. A couple of other points. So how can we guarantee economic growth, but at the same time reduce the emissions? So the CO2 emissions are a function of a GDP, say. GDP is a measure of the products that we produce, okay? But we can actually see it as the product of a GDP times the economic energy intensity. So how much energy do I need to produce, say, $1,000 of GDP? So how much energy do I need? So I can write this relationship as GDP times this ratio times another ratio, which is the green level of the energy production. Okay, so today the world produces 45 gigatons of CO2 every year. But if you are able to make this ratio, CO2 over energy, so how much CO2 we emit per kilowatt hour of electricity, we immediately reduce the amount of emission. So if we are able to produce the energy that we need, not with coal, not with gas, not with methane, but with hydro, photovoltaic, wind, that ratio will go down. Second, if we make the production processes more efficient, we can keep growing the economy, but needing less energy. Okay, so these are the 2 terms in which we can act, okay, and try to make the processes more efficient. We need to transform them, and we need to think about how we generate the energy that we need and transform it, okay? How did Italy do it if we look back in the past 40 years on these terms? So what you see here, and these are graphs that I built using data from the World Bank database, our working data. So in black, you see the CO2 emissions as a percentage of emissions in 1990. So with respect to 1990, so in 1960, we were emitting a quarter of that. Then Italy kept increasing the emissions compared to 1990 until 2005, and then it started reducing them. In red, you see Italy GDP, how much it has been growing, okay, during that period. In blue, you see the energy over GDP. What you see here is that from 1970 onward, we have been able to improve the efficiency of our production, okay, of our GDP generation. But if you look at the gray is how much CO2 we emit to generate a unit of energy. We haven't really done much. We haven't done much until 2008. Italy from 2007, 2008 has actually built a lot of solar and aeolic power stations. So we managed to reduce this number, but tiny, by tiny value. Now, how can we reach a 50% reduction of CO2 by 2030, for example? Keeping the economic growth as in the past decade. So how can we do that? Now we want to reduce the emission. We need to reduce the emission by 3.5% every year from this year. If we do that, we get to 2030 with a 50% reduction compared to 1990. Okay, so target number one, this target number two, we want to do it keeping the economy growing. Can we achieve it? Yes, we can. For example, we can if we are able to reduce the emissions per unit of energy by 2.5% per year. How? Well, switching off coal power stations and switching on hydro, aeolic, or photovoltaic. And second, by reducing the energy required per unit of GDP, by improving the efficiency of our GDP generation processes by 20%. Okay, so it's mission possible. We can actually achieve this target, but we need to work on these aspects. Okay, so in conclusion, what did I show you today? First of all, I've reminded you what IPCC says. It's unequivocal that human influence has warmed the atmosphere, ocean and land, and that widespread and rapid changes have occurred. The report confirms that the future warming could be controlled if emissions are reduced dramatically, faster than it has been done so far. Third, we have a technologies. This is my point. I think we have a technology. We don't need to wait for nuclear fusion. We don't need to think about new nuclear fission, small plants, whatever. We have a technology to actually generate the energy we need. We just need to invest in that. Okay, we must aim for a decarbonized, sustainable, and clearly just society. This is probably one of the points we will be discussing. And my fourth point is about some work that I've done with Alberto Pirni and Fausto Corvino, which is this issue of how can we do as individuals, what the government role should be, helping individuals and firms to achieve the targets that they talk about. Well, I think governments should agree and enforce immediate actions to reduce emissions. Without clear messages, laws, realistic carbon taxes, incentives to reduce emissions, I don't think we will go far. I think we will continue to emit and we will continue to grow the emissions. Okay, so this is a comment that I would leave for you to debate. So with this, I finish my presentation. Thank you. So I don't know if there are a couple of questions. I can maybe stay for 2 minutes. Yeah.
In fact, we don't want to abuse your time, Roberto. So I don't know I see people clapping. I don't know if there's anyone here who wants to ask Roberto a question. Otherwise, are you going to be with us tomorrow, maybe?
I will try.
Okay.
I will try to connect.
All right, because we don't. I really don't want you to be late with your meeting.
Yeah.
So
yeah, but we have a question. Go ahead.
Please, Dan. Sorry, Dan. You need to come and speak at the microphone.
Thank you. That was a great talk. So you said that the IPCC largely confirmed what we already knew, and I was wondering if you could, there are 3 or 4 other things that the IPCC said in the report that were really new, that they hadn't said were really, from a policy perspective, that are the important takeaways from the report.
Yeah, okay. Another very important point that IPCC made, and this was known in the scientific community, is that, for example, nature is finding it more and more difficult to absorb CO2. So, as you know, we emit every 100 gigatons of CO2, we emit roughly 50 of them are absorbed by the ocean or by vegetation. So the capacity of the ocean and of vegetation to absorb CO2 is decreasing as the climate warms, unfortunately. The oceans are becoming less able to absorb it, and vegetation as well. Now, if you put vegetation under water stress, under heat waves, to fire, then clearly vegetation is not capable to absorb as it should. So this is another point that IPCC made, which was, I don't think was there in the assessment report number 5. Now, in the scientific literature, we have been talking about this, the fact that as we keep warming, we cannot expect the nature to keep doing this cleaning job for us, okay? So the danger is that we're going to, and the second point that I would mention is that they clearly mention the possibility, they clearly mention the fact that we might see some rare, extreme changes in the climate, so-called point of no return. The Arctic might get to a stage where it will melt and not being able to freeze substantially even in winter. Greenland glaciers might melt to a point that it will continue to melt. The Amazon forest is going to be destroyed at such a rate that from being a sink of CO2 is becoming a source of CO2. So again, the message is we cannot wait for technologies, which is, for example, something that some people even in Italy are saying, we cannot wait for technology to do the job for us in 10, 20, 50 years. We need to act now because the problem in 20, 30, 50 years will be even bigger. And we need to really control the warming to avoid to get there. Okay, thank you very much. I'm sorry, but I really need to leave you.
Okay, can you hear me now from home? Yeah. Okay, so many thanks to Professor Buizza for his excellent introduction to our workshop, and of course a warm welcome also from my side to all of you. Those of you who are present here in the room of our Scuola Sant'Anna and those who are participating from home. Let me open this session by thanking, first of all, our speakers for this session, and therefore Professor John Knox, Professor Elisa Morgera, and Professor Karin Arts, who is here, for having accepted to present their thoughts and their reflections on the human rights implications of climate change. It may sound as a sort of rhetorical statement, but it's not actually. We are really happy to have the chance to listen to your presentations, and we are very happy to have the possibility to discuss with you your papers later on in the discussion. Let me just say a few words as a matter of introduction to our session. Just two or three statements that are in line, I think, with what Roberto Wizza was saying some minutes ago. The first statement or the first point is the following. As the title of the workshop suggests, we assume here that climate change has a highly transformative force. And I think this is something that it was implicit or inherent in the presentation, the short presentation given by Roberto some minutes ago. We assume that climate change has, or let's say, it's not a purely technical issue. Of course, it is a technical issue. We cannot deny this aspect, this dimension. But it is also a phenomenon which is capable or potentially capable of reshaping the policies of legal and political orders, their economies, and therefore their models of growth, but also their social structures, their societies, precisely as Roberto said in his introduction. Remarkable example of this, I think, is that of the EU. As we all know, the Commission has launched in December 2019 a program which is the European Green Deal project, which aims at responding to the climate change issues. And this project has, again, a purely technical objective, apparently, which is that of climate neutrality. But at the same time, in order to realize that purely technical objective, it assumes that we need to build a new European society, to use the Commission's words, the European Commission's words, that we need to establish a more advanced growth model, and that we need to reshape our policies, the set of European policies, the policies that are available to the European Union, starting with industrial policy. So we need to invent a kind of new type of industrial policy in the EU. So perhaps the EU is a particularly spectacular, I would say, example of the potential impact of climate change on a polity. But I believe that it's not at all an isolated example. There are many other cases in which we can find the same kind of transformative force exercised by climate change on the policies, the economic models, and also the social models of different legal and political orders. My second statement is, again, I think, quite in line with what Roberto just said, and it's the following. When we try to explore this transformative force of climate change, we must perforce consider the broad picture, the broad canvas of the globalized legal space. And I'm using here a very generic and broad formula to refer to what somebody else might consider the global governance. And I'm pointing to the globalized legal space or to the global governance because we actually have an impressive number of regimes, bodies, entities, organizations, actors that are now at work in the field of climate change in the globalized legal space. They are states, of course, they are international organizations, but they are also transnational organizations, they are subnational entities, they are supranational entities like the EU, they are global regulatory systems according to a specific kind of understanding of the global governance, and they are also private actors, as Roberto was saying before, not only individuals, however, but also companies and other kind of organized and the important thing is that all these multitude of actors and organizations and entities tend to create linkages, a great variety of linkages between themselves. They can be horizontal or vertical linkages, if I may use this spatial image, which is perhaps wrong, but it helps us to understand what I'm trying to describe. They also exercise overlapping tasks and functions, for example, regulatory functions, but also adjudicatory functions. And they also develop overlapping policies or policy objectives. Or let's say they develop policies that are partly converging around a single, a unitary purpose, which is that of climate neutrality. But at the same time, they also diverge because they identify specific, different, unique objectives that perhaps tend even to conflict or to compete between themselves in the globalized legal space. So my second point is the following. Of course, each of us works on a specific dimension, on a specific part of this huge and complex and really complicated picture, which is the globalized legal space. But the only way, I think, to understand the transformative force of climate change is to consider the globalized space as a whole. There are no other options, I would say. It's complex, it is really complicated, we know that, but we have to make an effort in order to at least to reconcile our, and to make them, to reconcile our individual points of view and to reconcile them in a, to combine them in a unitary explanatory framework. My third and last point is the following. And it connects this general framework to a specific issue of our session. It is within this context, it is within this overall context, this general context, that we have to situate also our specific discussion on the human rights implications on climate change. The assumption, the simple assumption, I would say, is that climate change, or better, the responses provided by the polities or the legal regimes at work in the globalized legal space to climate change have an obvious impact on human rights. But we also assume that the way in which, or let's say, the responses provided by the legal and political orders are in turn reshaped, modified, informed by the ways in which human rights are actually exercised, for example, before courts or in other possible potentially relevant fora. And of course, here the most obvious example of this influence of human rights on the overall regulatory framework is that of strategic litigation, which is becoming a transnational phenomenon, growing importance, which is studied also by some of us present here in this room. So our way to explore the issues raised by the continuous interactions between human rights and climate change is to consider, first of all, how human rights treaty bodies, which I would define as, let's say, the administrative or perhaps technocratic parts of the treaty organizational architecture, will address in the future climate change. Now, this is a title of Professor John Knox's presentation. The title is actually put in the form of a question, but it's not a statement, but not modifying too much the substance and the sense, the meaning of the title. We begin with John Knox's presentation because we have read minor change in the program, but it's nothing, complex to manage. Just to say a few words on Professor John Knox, I just recall that Professor John Knox is a professor of international law at the Wake Forest University, sorry. And I recall that he has a special expertise in the field of human rights law and international environmental law. That in particular, he has worked extensively, both in terms of scholarship and in terms of institutional engagement, in particular within the UN context, on the intersection of human rights and environmental protection. So he's really the best possible speaker on this topic. So Professor Knox, we are really glad to have the chance to listen to your presentation and to your thoughts and reflections. The floor is yours. May I just ask you to keep your intervention between 20 and no more than 25 minutes, let's say, if it's possible. Thank you. Please, the floor is yours.
Great, thank you very much. And thank you to all the organizers. Thank you to Emanuele and Chiara, and to Gaetana for her introduction, and to Roberto for setting the factual context. It's a pleasure to be with you today. I'm only sorry I can't actually be with you today. I would love to be in Pisa. Let me try and share my PowerPoint here. This should work. Oops. All right. Can you see this all right?
Yeah, it's fine.
Okay,
Perfect.
great. Turn it into that. Okay, so as you just heard, I'm going to talk about climate change and how it's going to be and is already being addressed by the human rights treaty bodies. First, we have to start with a little bit of a basic background, I think, here. I don't think that this will be news to anyone listening, but let me go through this anyway. So climate change obviously undermines the enjoyment of a vast range of human rights, including rights to life, to health, to an adequate standard of living, including the various components of that right, such as rights to food and water and housing. Because climate change interferes with so many different human rights, that means that states have corresponding obligations to protect against its effects. And third, that means that human rights institutions, including in particular the ones I'm going to talk about today, the human rights treaty bodies, offer forums to address these issues and to hear climate cases. So let me say a few more words about each of these points, and then I'll focus more on the treaty bodies in particular. So again, I don't think this requires a lot of elaboration at this point. Mary Robinson said years ago that climate change is the greatest threat to human rights in the 21st century. And I think there are a lot of, there's a long history now of elaboration of that point. If we go all the way back to the Inuit petition brought to the Inter-American Commission on Human Rights in December of 2005, which is now over 15 years ago, that petition set out in great detail how climate change was already affecting the ability of the Inuit people to be able to live life in the way that they had been for millennia, for generations living it. That is, it was affecting their rights to life, to health, to food, to culture, and so forth. Even though the commission did not, of course, accept this case and certainly didn't issue any decision on it, it did pave the way for a number of other similar statements, such as the Male Declaration, the first time that a group of governments had connected the harm caused by climate change to the effects on their people's ability to enjoy human rights. It was adopted by small island developing states in the Maldives at a conference hosted by the Maldives in its capital island of Male. That led in turn to the Human Rights Council at the United Nations beginning to adopt a series of resolutions on human rights and climate change going all the way back again to 2008. So again, this is certainly not a new history any longer. The Human Rights Council, the most important intergovernmental human rights body at the United Nations, now regularly connects the effects of climate change to human rights. The Office of the High Commissioner for Human Rights was asked by the Council very early on to adopt a report or to prepare a report on the effects of climate change on human rights. Again, this is a kind of a brief review of the history, just to drive home the point that this is not new. The effect of climate change and the ability to clarify and describe the effect of climate change on human rights, these are not new points. So as a result, that means that states have duties to protect human rights from environmental harm, including harm caused by climate change. This, again, is not, I think, a particularly new point in many ways, although it's one that's become clearer and clearer over the last 20 to 25 years. In particular, because the United Nations does not recognize, at least as of the moment, it does not recognize a an overarching human right to a healthy environment. At the international level, human rights bodies have applied human rights to environmental harm through what I've called greening human rights. That is, they've taken existing human rights, such as rights to life and health, and explained how environmental harm interferes with them, and therefore how states have obligations to address, to protect against such harm. So this has happened as a result of decisions by the European Court of Human Rights, the Inter-American Court of Human Rights, special rapporteurs, treaty bodies, and so forth. This in turn has created a quite extensive jurisprudence to which the regional tribunals, but also other international human rights bodies have contributed. So as a result of cases brought to these bodies, reports that they've issued sua sponte, statements they've made, there's a kind of a body now of environmental human rights law. That includes treaty bodies. That is, treaty bodies have been involved in this process. In my role as the United Nations Special Rapporteur on Human Rights and the Environment, I was asked to, in 2012, by the Human Rights Council, to clarify the relationship between human rights and the environment. And I undertook a mapping project in which I essentially tried to describe what different international human rights bodies had said about environmental issues. Part of that mapping project was to look at what treaty bodies had said. And so I issued a total of about 14 reports, 5 of which were on treaty bodies in particular. These were the 5 I looked at. Together with the other sources of environmental human rights law, the treaty bodies and all of the rest developed a set of norms, a set of obligations of states. Now, to be clear, not all of these obligations are necessarily accepted by states as legally binding on them, although many are. But the point is that this is an emerging body of law that is based on hard law. This is not just based on declarations or resolutions or things like that. It's based on these treaty bodies and others' interpretation of binding human rights treaty law. Without going into great detail about the obligations, they fall into 3 major categories: procedural obligations, which include such things as duties to provide information and facilitate public participation; substantive obligations to adopt and implement and then enforce environmental standards; and obligations not to discriminate and to protect those who are most at risk from environmental harm. In my final report to the Council in 2018, I summarized these obligations in what I called framework principles on human rights and the environment. My term ended, but the mandate continues. David Boyd, a professor at the University of British Columbia, was appointed to take over the mandate, and he has served admirably ever since. So let's focus a little bit more on treaty bodies now. How are treaty bodies addressing these issues? Treaty bodies, I would say, were not at the forefront of creating the jurisprudence of environmental human rights law, but they are making up for lost time. They are rapidly addressing these issues more and more. So, for example, in 2018, the Human Rights Committee adopted its General Comment number 36 on the right to life, which addresses environmental threats to the right to life. The next year, the Human Rights Committee, which I should say oversees the International Covenant on Civil and Political Rights, issued its first major environmental case in Cáceres v. Paraguay, and 2 other treaty bodies, the Committee on Economic, Social, and Cultural Rights, which oversees the covenant by that name, and the Committee on the Rights of the Child, which oversees the covenant on the rights of the Convention on the Rights of the Child. They both are currently drafting general comments. The CRCs in particular will focus on the environment. So what do these general comments and other actions do? Just again, briefly, to give you the kind of context here, the Human Rights Committee's general comment in 2018 says not only that states have the duty to protect life, but that that duty requires them to take appropriate measures to address general conditions in society that directly threaten or prevent individuals from enjoying their right to life with dignity. And it specifically refers to degradation of the environment as one of these conditions. In particular, it says that states should be taking into account their obligations under international environmental law to inform their obligations to protect the right to life, and vice versa. That is, they should ensure that the right to life, their obligations under the right to life, to protect and respect the right to life, should also inform their relative obligations under international environmental law. That means, among other things, and again, this is all based just on one article in one treaty, the Article 6 on the right to life. It says, the committee says that states should therefore ensure sustainable use of natural resources, develop and implement substantive environmental standards, conduct environmental impact assessments, and so forth. Again, this is extremely consistent with how other treaty bodies and other human rights bodies generally are approaching these issues. In order to protect these rights from environmental harm, states have specific obligations to protect the environment. In the Portillo Cáceres v. Paraguay case that was decided 2 years ago, the Human Rights Committee was faced with a situation involving massive fumigation of agricultural chemicals, which had resulted in harm to people, including the death of one person. The fumigation had not taken place in accordance with Paraguayan law, but Paraguay had not adequately enforced its law. And so, again, the Human Rights Committee said, okay, this violates the right to life as protected in Article 6, but also the right to private and family life in Article 17, and the right to remedy. And as a result, it said Paraguay has specific obligations to conduct an investigation, sanction all those responsible, provide full reparation, and adopt preventive measures. One of the members of the committee, Elaine Tigruja, was quoted as saying, hundreds of similar cases around the world could be submitted for our consideration. I think we can expect many more, perhaps not hundreds, but we can expect many more cases to be decided by the Human Rights Committee on this issue. So, what are they saying about climate change in particular? I'm going to say a few words about each of these recent developments. So, in 2018, the Committee on the Elimination of Discrimination Against Women issued a general recommendation that had a lot to say about climate change in particular. In 2019, 5 treaty bodies issued a joint statement on climate change and human rights. In 2020, the Human Rights Committee issued a decision on climate migration and what rights climate migrants have under the International Covenant on Civil and Political Rights. And they're increasingly, all of the treaty bodies are increasingly addressing climate change through their concluding observations on country reports. And finally, there are 2 pending cases, both of which directly implicate states' obligations involving climate, one before the Human Rights Committee that was brought against Australia, and one before the Committee on the Rights of the Child. So let me say a few words about each of these recent developments. The CEDAW Committee's General Recommendation number 37, which was adopted in 2018. The full name is that this recommendation was on the gender-related dimensions of disaster risk reduction in the context of climate change. Not the most easy to remember title, perhaps, but the point is that the committee was looking at the effects and the obligations of states with respect to the effects of disasters generally, but in particular with a particular focus on climate change. This is a very detailed, rich general recommendation. I'm not going to try and go into great detail about it, but I do want to just highlight a couple of points. One is that they said that states should ensure that their measures are grounded in human rights-based principles, and highlighted in particular equality and non-discrimination, participation and empowerment in development, implementation and monitoring, and accountability and access to justice. So this emphasizes something that many human rights bodies have long emphasized here, that individuals, especially individuals that have been historically marginalized or disadvantaged and or are more at risk from climate, they must be involved in the decision-making process. They must be involved. Their voices must be heard as the decisions are made about what to do about climate change. And if their voices are not heard, or whether they are or not, they should also have rights to access to justice. They should be able to go to court to be able to enforce their rights. The general recommendation made a lot of more specific recommendations, including with respect to the importance of, for example, disaggregating data, so people have more of an idea of what the effects actually are on marginalized segments of the population, especially women and girls. They talked about rights to health, adequate standard of living. They spoke about climate migration. The point is, again, without going into detail, the treaty bodies are increasingly confident in operating in this space and telling states what they should be doing in order to protect human rights from climate change. Treaty bodies' joint statement is really kind of a major historical event in this process. 5 treaty bodies joined in this statement: the CEDAW Committee, the Committee on Economic, Social, and Cultural Rights, the Committee on the Rights of the Child, the Committee on the Rights of Persons with Disabilities, and the Committee on the Rights of Migrant Workers. Notably, the Human Rights Committee did not join this. Neither did the Committee on the Elimination of Racial Discrimination, for reasons, frankly, I'm not totally sure about. But anyway, we can kind of speculate about that. The point is that this joint statement set out a pretty strong set of principles with respect to the shared approaches of these treaty bodies towards climate change. This is not by any means the entire joint statement, but just to highlight a few of the points. They highlighted the effects of climate change on the people that are protected by their treaties, in particular segments of the population already marginalized or in vulnerable situations. They said that all state parties have obligations, including extraterritorial obligations, to protect and fulfill human rights, and that failure to take measures to prevent foreseeable human rights harm caused by climate change could constitute a violation of those obligations. Again, this is pretty strong language from treaty bodies, and it was, again, not prompted by a particular case. It was prompted by their desire to make a joint statement to get ahead, I think, of these issues a little bit. They particularly emphasized the importance of international assistance and cooperation on the part of high-income states, and the importance of cooperating in good faith in the establishment of global responses addressing climate-related loss and damage suffered by the most vulnerable countries. So I think this is another theme that we're going to increasingly see from the treaty bodies about the importance of the states that are richer, that have done more to actually create this problem, the importance of their actually helping the states and those in the states that have done less to contribute to the problem and are more at risk. So to get a little bit more specific still, the Human Rights Committee in January of 2020 issued its first ever climate case, and a case brought by Ioane Teitiota, a national of Kiribati, who had filed a submission with the Human Rights Committee arguing that New Zealand had violated his right to life by returning him to Kiribati. He was living in New Zealand. I guess he overstayed his visa authority and did not want to be returned to Kiribati, and argued that the New Zealand government could not do so consistent with their obligations under the International Covenant on Civil and Political Rights. To be clear, his argument was not that he was a climate refugee, although that's how it often was portrayed in the media, because the Refugee Convention doesn't really cover situations like this. But the Human Rights Committee had already held that states have an obligation of non-refoulement, an obligation not to return people to countries where their right to life would be in jeopardy. So that was essentially the basis for his argument. The committee actually accepted a number of his claims. It accepted his claims that there are already violent conflicts between claimants to land in Kiribati as a result of rising sea levels. Fresh water has to be rationed. It's difficult to grow crops already, and that sea level rise is likely to render Kiribati uninhabitable in 10 or 15 years. Nevertheless, it did not hold that New Zealand had violated the ICCPR. And the reason it did this is, I think, important to understand. It said that to win, he had to show a risk of irreparable harm under Article 6 or 7, which covers personal integrity. So the idea is basically, if there's a risk that I'm going to be tortured or killed if I'm returned to my country, then you can't send me back. He has to show that that risk is real, personal, and reasonably foreseeable. Even then, the committee has a position of deference to the state. So it will uphold the state's decision unless its assessment, the state's assessment, was clearly arbitrary or manifestly in error or a denial of justice. So essentially it deferred to New Zealand on this. Because New Zealand had pretty carefully gone through this analysis, including by taking into account the international covenant, and it decided that he was not actually going to be in danger of his life if they returned him. So for the moment, then, I think as long as states do consider the consequences of returning people to their countries, the committee is very likely to find a violation of the ICCPR. But it put down an important marker for the future. The committee said that without robust national and international efforts, the effects of climate change in receiving states may expose individuals to a violation of their rights under Article 6 or 7, such that states could not send them back. So I think it's essentially sending a kind of warning to states of the world to say, we're not going to hold that you're violating human rights law by sending people back now, but that could change quite quickly in the future. I also wanted to just take a minute to note that the treaty bodies are increasingly referring to climate change in their concluding observations on states' reports. In addition to receiving communications from individuals alleging violations, the committee receives regular reports from states on their compliance with their obligations under each of these treaties. This is a chart from a really valuable report by the Center for International Environmental Law that went through and looked to see exactly what the treaty bodies were saying about climate change. You'll note here that the committees that have been most active in recent years are the CEDAW Committee and the Committee on Economic, Social, and Cultural Rights and the Committee on the Rights of the Child. Those three committees have created the bulk of the statements in concluding observations. Many of these have been directed at small island developing states or other states that are trying to adapt to climate change. In other words, much of what the committees that have been focusing on this at all have been focusing on is the importance of adaptation. They've been telling states like the Maldives, for example, you need to make sure you're adapting to climate change. They also have said a lot about procedural obligations. That is, again, the importance of having people be able to contribute to and participate in the decision-making process. But there's increasing attention to mitigation as states from the global north come up and are having their reports reviewed by the committees. The committees are increasingly saying things like this. So these are both from the Committee on Economic, Social, and Cultural Rights. In 2019, it criticized Switzerland for not making the necessary efforts to achieve their greenhouse gas emission target for 2020. Similarly, in Norway, it said that Norway should be intensifying its efforts. It recommended that Norway reconsider its decision to increase oil and natural gas exploitation. I expect these kinds of the use of this kind of language is going to get stricter and sterner over coming years. There's going to be stronger language used against, I think, states from the global north that they need to do more to mitigate. There is a lot of interaction, I think, and synergy between the international treaty bodies and domestic litigation, and to some degree, each of them are going to be continuing to influence the other as they go forward. Finally, the two pending cases. One is pending against Australia. It was brought by Torres Strait Islanders. These are inhabitants of islands between Australia and New Guinea that are also subject to rising sea levels. They are alleging that Australia has failed to comply with its obligations with respect to mitigation and adaptation in order to meet its obligations under the human rights, under the International Covenant on Civil and Political Rights. Briefs have been filed in that case. Really, it's teed up for the Human Rights Committee to decide it, but I don't know how much longer it will take to do so. This case got more attention, I think, in some ways, at least outside of Australia. This is a case brought by Greta Thunberg and 14 or 15 other children and youth against 5 states: Argentina, Brazil, France, Germany, and Turkey. It was filed 2 years ago. It also has been fully briefed and argued. They held oral hearings in this case where the committee, among other things, virtually met with the children and youth. David Boyd, the current special rapporteur, and I filed amicus briefs in both of these cases. This case in particular, the Committee on the Rights of the Child is considering admissibility first. So there's going to be a question as to whether, first the case has to get past that hurdle. The plaintiffs in this case, the children and youth, did not exhaust local remedies, which is normally a requirement, but they argued that they don't have to because remedies would be futile. So that will be an issue that the committee has to address. So just to sum up then, I think the lessons are that treaty bodies are increasingly addressing climate change in both individual communications and concluding observations, as well as in avenues like joint statements, and that this is obviously part of a broader trend that you're going to hear a lot more about, and that there's a synergy between what the treaty bodies are doing and what domestic courts are doing. And then finally, a note of, I would say, caution, if not pessimism. As important as this tool is, and I think it is quite important, I want to emphasize that no one should think that this by itself will be enough to actually fix the problem, so to speak. It's especially unlikely to influence the two biggest single emitters, China and the United States. And I think for countries like Russia as well, it's unlikely that the views of the treaty bodies are going to, let's say, influence their conduct very much. Having said all of that, though, I think these are still very important developments and that they will influence, together with other efforts, the behavior of many other countries. So thank you again for allowing me to be here, and I hope I stayed within my time. I look forward to the rest of the conversation. I unfortunately may have to leave a little early because I have a class to go teach, but I'll stay as long as I can.
Okay, many thanks. Perhaps you can't hear from home, but there was a clap, a big clap here in Pisa. So many thanks also from my side for your presentation, which was thoughtfully interesting and I think also unconventional in the sense that you stressed a number of points that are not always at the center of the discussion on the human rights implications of climate change. Now, I don't know exactly how many minutes you have in order to have a discussion, but I would propose if you have, let's say, at least a quarter of hour or 10 minutes or whatever to collect some questions here in class.
Yeah, I'd be very happy to. I can. I know you have two other great speakers. I will have to leave in about 20 minutes. So that's
okay. Perfect. That would be perfect. So let's open the floor to the discussion, and I would encourage to raise questions here in Pisa, but also from those who are connected from home. And there are also people following our session from the YouTube. So perhaps they also have the possibility to raise questions that will be collected and then read here at the microphone. Okay, so we have Emanuele. Please come here so we can hear you, please.
Can you hear me? Yes.
Yes.
So thank you so much, John, for your very, very insightful presentation. And I must say that I obviously fully agree with everything you said. I had one question which relates to the Teitiota case, which actually I might also address to Karin later on, which relates to the fact that Mr. Teitiota did not stress very much or did not point to the fact that not only he and his wife, but also his children would have been subjected to refoulement and were actually then sent back from New Zealand to Kiribati. So I know that New Zealand is not a party to the 2011 optional protocol, so they wouldn't have been able to file a complaint with the CRC. But my question is, do you think that complaining to the CRC or maybe to other treaty monitoring bodies which have a similar competence would have been more effective in terms of being able to stay in New Zealand? So do you think that, for instance, the Committee on the Rights of the Child, given that children are usually, let's say, better protected, so to say, against this sort of potential human rights infringements, would have given him a better chance of success of obtaining a right to stay in New Zealand? Thank you.
Yeah, that's a really interesting question. I think all of the treaty bodies, to some degree, as are domestic courts, they are all grappling with issues of causation, and the existing law that the Human Rights Committee had developed over years with respect to non-refoulement, just didn't really look like, it didn't have long chains of causation as much. It was much more, will you be an imminent threat, as soon as you returned? I think one of the ways in which this jurisprudence is fairly rapidly developing is to expand the notion of imminence to include ideas of harm that are certain to occur, but over longer periods of time, unless they are averted now. In other words, the causal chain is fairly certain, but the period of time over which it's going to take place is longer than the treaty bodies or courts have been familiar with. I know that this is one of the issues that has come up in the context of the case currently pending before the Committee on the Rights of the Child. I don't know, I'm not at all familiar with the thinking of him and his lawyer in that particular case, but they may have just been thinking that the Human Rights Committee's jurisprudence is that they had better luck going with a more established jurisprudence. I want to emphasize that we are in the very early days of this jurisprudence developing at the treaty body level, and I think one of the things that the treaty bodies are trying to be, they're very aware of the fact that the decisions they're going to be making are going to set precedents that are going to come back to them for years. So they want to try and get them right at the beginning. Just to close out on this, I do think increasingly you're going to see at the treaty body level, just as we have seen at the domestic court level, more and more of these cases are brought by children and youth. And the Committee on the Rights of the Child, that's why that case in particular will be very interesting to see what happens. The case against Australia before the Human Rights Committee, by the way, the Torres Strait Islanders did emphasize very strongly the effects on their children. And so it'll be interesting to see how the Human Rights Committee addresses it there. I see I have a question from Annalisa. Should I go ahead and answer that in the chat?
Can you read the chat? Are you able to read the chat?
Yes.
Yeah.
Annalisa said, if I wanted to be a little critical of the treaty bodies, what would I say is the greatest gap in their activities concerning climate change? I think the Committee on the Rights of the Child, I know members of the committee, and I don't mean this in any kind of personal way. Obviously, they're very, very hardworking and committed people. I think it's been rather slow to address the long-term effects on children of climate change. I think it is trying to make up for lost time now, but I think it's been a little bit slow. I was at a day of general discussion that the Committee on the Rights of the Child held in 2016, now 5 years ago. We thought that was going to lead to a general comment in the shorter term. They only have just decided now, 5 years later, to issue their first general comment focusing on the environment. I think given the nature of climate change, I think that's unfortunate. I think the committee would have done better to jump in much earlier. I could say other things. All of this is about pushing them or hoping that they will take action more quickly, but at the same time, obviously these are people that have a lot of demands in their time. There are a lot of other threats against the rights that they're covered in their mandate. So I don't want to suggest that they've somehow been slacking off or anything like that, but because I don't think that. But I do think that looking back, 5 years ago would have been a better time, I think, for all of the committees, and maybe 10 years ago, really, for the Committee on the Rights of the Child to really start focusing more sharply on these issues. So it's not so much that I'm critical of what they're saying right now or the direction they're moving. I just wish they had started earlier.
Thanks. Yes, there is a question in the room. Please, can you come here to the microphone? Just 1 second.
Thank you very much, Professor Knox, for a really interesting presentation that I can nicely follow on to later when I will be speaking more specifically about children's rights. I wanted to ask you, you focused a lot on greening existing human rights law, whereas well, what we also need to do perhaps is, and I don't know how exactly to say that in English, but is integrating human rights into existing environmental, including climate change law. And we've seen a first piece of that in the preamble of the Paris Agreement, but on the whole, very little has been happening on that front. So I wondered how you see also strategically maybe where the priorities should be. Should we stick with greening what we have, or should we also invest in developing really new and more integrated international legal frameworks? Thank you.
So that's a really good question. Obviously, I totally agree that it's important not just to green human rights, but also human rights. If that's actually not, it's too bad we don't have a word like green that we could use for the, you know, infusing human rights into international environmental and domestic environmental law. Because I think that's really important. As you say, the Paris Agreement, as a result of a great deal of work on the part of many people, there's a preambular reference to human rights in the Paris Agreement. I think since then, I mean, others here may be following this more closely than I have, but I'm disappointed in the follow-up to that within the talks under the auspices of the UNFCCC COP. I'm disappointed, but I would say not totally surprised. It's always been a challenge to try and insert human rights considerations into international environmental talks. However, I think there are a lot of people that are working to do that. One way that needs to happen is through making sure that safeguards reflect human rights considerations in international climate finance arrangements, including under Article 6 of the Paris Agreement, but more broadly as well. There are some good examples of that already. The Adaptation Fund actually has pretty good safeguards, but that needs to be made more consistent. And I feel like I've been saying the same thing about this for at least 6 or 7 years, and I feel like that needs to get more attention. In terms of brand new legal frameworks, I am skeptical, frankly, that that's worth trying. The reason for that is because we already have legal frameworks on this, and it has taken a huge amount of time to set them up. They are already being interpreted in ways that I think are moving in the right direction. I'm very skeptical about the value of taking energy away from that to create new legal frameworks that would basically reproduce many of the same issues we've been struggling with. I mean, I'm open to hearing how that would improve things, but I feel like, especially in the human rights side, the legal frameworks are there. I do think one gap is the absence of United Nations recognition of the human right to a healthy environment. That is going to be on the agenda of the Human Rights Council this session, the session that just started today. And so I am hopeful that by the end of this month, we will have for the first time a clear statement from the United Nations intergovernmental system, the Human Rights Council in particular, that there is a global human right to a healthy environment. I don't want to overstate how much difference that would make, but I do think it would be a major step forward. But in terms of new treaties or things like that, no, I'm not. I just think the time it would take to try and develop a legal framework like that would be probably not worth the effort. We just don't have time, really. We have to move more quickly.
Okay, we have time for perhaps a couple of questions more. Please, the microphone.
Thanks, John. Great talk as always. Sorry you couldn't be with us here in Pisa. So I had a follow-on question really about the relationship between the treaty body work that you're describing and the Paris Agreement. The Paris Agreement was based on the principle of national self-determination. It's a national determination of mitigation contributions. And it replaced, as you know, the Kyoto Protocol, which took a more top-down approach where countries internationally negotiated their contributions. The human rights treaty bodies, as you're describing them, are taking an even more top-down approach where they're themselves defining, in a sense, what the mitigation contribution should be of countries like Switzerland and Norway. So I was just wondering if you could comment on how you see the relationship between the human rights treaty bodies and the Paris Agreement, because they seem to be diverging quite substantially in sort of the approach. And do you see a potential clash there? And in particular, since the treaty bodies are only relevant for countries that are parties to the treaty bodies, and as you mentioned, the two biggest emitters, the US and China, are not parties to some of the key treaties involved, how you see that playing out in the Paris Agreement context. So thanks.
Yeah. Hey, Dan, good to see you. So I actually don't want to leave you the impression that I think the treaty bodies are taking a kind of top-down approach that would be inconsistent with the approach taken at the Paris Agreement. I don't think that's the case, actually. The overall approach of international human rights institutions towards the environment has been to distinguish between procedural obligations, which they're pretty strict on, and substantive obligations, which they allow states to have much more discretion about. In other words, no human rights body is out there saying you have to have 0.05 parts per million of sulfur dioxide in the atmosphere or you're in violation of your human rights obligations. There just aren't cases like that out there. What they do say, however, on the substantive side is that while you have some discretion to decide for yourself what makes the most sense, once you've struck that balance, we are going to hold you to it. In other words, once you've said through your own political system, as long as you meet the human rights requirements of making sure that everyone was involved and you adequately assessed the problem and you made an informed decision, we're going to give you a lot of discretion. But once you strike a balance, you have to actually do your best to implement it. So where you will see the treaty bodies continuing to use Paris and the commitments of states in relation to Paris is holding them to what they said. In other words, at least, or trying to hold them to what they said. So when states have said, well, we have to do X, or we're committing politically at least to do X, but then they don't do anything that would put them on a course to actually be able to do X, whatever the X is, that's, I think, where you're going to see the treaty bodies saying more, you're not doing what you said you were supposed to be doing. Now, having said that, will that be all they say? No, probably not. I mean, I think certainly not, because in some cases, the state's commitments are so short of what any reasonable person would think is required for them to do, then the treaty bodies will be pushing them to do more. But I expect that they'll be using pretty general language on that. I don't personally anticipate treaty bodies are going to be coming up with percentage reductions that, that the members of the treaty bodies decide are the right reductions for states to be using. They're going to be looking wherever they can to see what states themselves have been saying, because that's what they've done in the environmental context generally, and that's what regional human rights tribunals have done. So I think actually, what the Human Rights Committee said in its general comment about how states should be taking their international environmental obligations into account in interpreting Article 6, but also Article 6 into account in interpreting their international environmental obligations. I think they're going to be try to be quite careful to construe their human rights obligations consistently with their international environmental obligations. I mean, who knows what will happen going forward, but that's what I would. That's my prediction. Now, as far as the United States and China goes, or for that matter, there's lots of countries you can pick. Will this really make an absolute difference in their behavior? I mean, has it in other contexts? I don't think there's any reason to think it's going to be somehow totally different in this one. If countries have ignored the treaty bodies in other ways, then they're not going to suddenly start paying attention to them now. But will it make a difference with some states? Yeah, I think so. Will it inform domestic courts in a variety of states? Yes, I think definitely. Will it change the kind of rhetoric and the way that we think about climate change policy, the kind of acceptable bounds of climate change policy, yeah, I think that's definitely possible as well. But I wouldn't, unfortunately, unless something really dramatic changes, I don't expect that what the treaty bodies are telling states will just have much influence over China and the US, which is a huge shortcoming.
Okay, many thanks. May I pose a last question? Perhaps if there is nobody else who wants to intervene from home or here. Well, what is interesting, I think, in your perspective, I would say, in your approach, is that you are suggesting, if I understand correctly your argument, that treaty bodies are, let's say, encouraging the development of human rights as principles to inform national measures. So they are developing human rights as principles, I would say, and as, you know, regulatory instruments, perhaps. Don't you think that in this way, these bodies are at the same time, you know, making something which is understandable, perhaps also useful and encourageable, but they are also neutralizing a bit the substance, the sense, the deep meaning of human rights themselves, which is perhaps more subversive. Human rights should be standards to contest, to verify the legality of the member states' obligations. So if you transform them in principles, shaping the regulations and the single rules and obligations, don't you think that there is the risk to lose the deep substance of human rights as a subversive, I cannot pronounce this word, legal instrument?
Well, I think, I mean, I don't mean to suggest that all of the human rights bodies are not going, I think I'm using a double, let me make that more positive. I do expect that human rights treaty bodies will find states not to be in compliance with their human rights treaty obligations with respect to climate change in specific cases. I'm not going to make a prediction about either of the pending cases, but, you know, it would not surprise me, for example, if the Human Rights Committee in the Australia case tells Australia you're not acting consistently with your human rights obligations in how you're treating the Torres Strait Islanders in respect of climate change. So if that's what you mean by subversiveness, that is actually telling states you're not meeting your obligations, you have to do better, not just take these into account, do the best you can, go forth. I expect there will be cases in which states are told you're simply not meeting your human rights obligations. What the point I was trying to make to Dan is more, I think, not just with respect to climate change, but with respect to the environment generally, human rights bodies are fairly reluctant to tell states exactly what level of environmental protection they should have. They're much happier telling them they have violated some kind of procedural obligations because they're more comfortable with that. But when the failure is manifest, they have been willing to tell states that they have violated their substantive obligations, not just their procedural obligations. And climate change, you know, for all the reasons we heard at the beginning, is alarm bells are going off, I would say, on climate change. We are passing the point now where it makes sense for treaty bodies or any other human rights bodies to be kind of just telling states, take these principles into account, come back in, you know, another 10 years and we'll see how you've done. We just don't have time for that anymore. And so I expect that treaty bodies' decisions will get more urgent and more specific and more critical of states' behavior.
Okay. Many thanks once again, John, for your excellent presentation and for the discussion. Have a nice class. And
Thank
see
you very much.
later on, I hope.
Yeah.
So we can now move to our bye-bye once again. Bye-bye. Yeah, people are, you can see them, but they are here and they are saying goodbye. Okay, let's now move to the second presentation that will be given by Professor Elisa Morgera, that I cannot see No, okay, she's there, I think, in the third box. Yeah. Okay. Hello, Elisa. Elisa is a professor of global environmental law at the University of Strathclyde, and she's also the director of One Ocean Hub, which is an international program of research and also advocacy, I don't know how to say, for sustainable development. She's an expert in the field of EU environmental law, but also international environmental law and also comparative environmental law. And she has worked extensively on the interaction between biodiversity law and human rights. In her presentation, Elisa is going to make some considerations arising from the nexus, the connection, the link between climate climate on the one hand, biodiversity on the other, ocean and human rights again. So it's a nexus between 4 different elements, if I understand correctly the title of your presentation. So many thanks, of course, for being with us, Elisa, and the floor is yours, please.
Thank you very much. And yes, the title is a bit of a mouthful, but hopefully I'll be able to explain things in turn. Mainly starting from, and I hope you can all see my screen now.
Yeah, we see very well. Yeah.
Okay, great. Yeah, and I think I'll start from discussing the connection between the ocean and climate change, and then move on and the relevance from a human rights perspective. And then I will look into how international biodiversity law may already help us to understand the legal connections, even if there may be different views about how strong these connections are and what is their legal nature, which I think will be a really interesting conversation. And it will speak to some of the points that have just been mentioned in the discussion on John's presentation. So starting from why the ocean is important and why it's not yet as center stage as it should be, both in terms of the international climate change regime, although there are movements in that direction, but maybe even more centrally for our purposes, why is it not more central, and shouldn't it be more central in our discussions on climate change and human rights? You probably all know that the science, the fact that the ocean is actually responsible for half of the oxygen we breathe and has really important functions related to greenhouse gas emissions and their absorption. But also there's many impacts of climate change on the ocean that in and of themselves may have implications for our human rights on land. And there's several international negotiations and fora in which ocean issues are discussed, and where I think we could have that integration that was suggested earlier in the conversation about considerations of climate change and human rights as part of other important issues at stake to develop the more holistic approach to all these interrelated challenges. One of the maybe complexities around understanding the connection between the ocean and climate change is that our knowledge of the ocean is still limited. We often say that we know more about outer space than we do about the ocean. And that's particularly true for deep sea biodiversity, which is also very relevant for the connection between the ocean and climate change. But we just don't know exactly how and to what extent, and how much we do not know yet about that connection. We do know already how important it is that marine life is declining and how dramatically it is declining, although there's indication that this is not irreversible. And that has to do partly with climate change itself, but also many other human interactions with the ocean, such as overfishing, exploitation of other marine resources, living and non, pollution, and health issues affecting marine life. Also, something that we often forget to discuss in the context of the ocean is how social and cultural values do play a role in how we understand biodiversity and its importance for human well-being, and how that may play a role also in the context of climate change responses. So against this complex and slightly unsettled scientific background, What we do not know, where we need more work to be done, is to understand how international human rights law applies to our decisions on the oceans, and particularly where decisions on the oceans and on land may be connected with one another. But surely, in terms of understanding the connection between human rights and the environment more generally, like John explained, and particularly human rights and climate change, the thinking has really been very much land-centric, land-focused. And we're only starting to even spell out what legal questions there are if we bring together human rights and the ocean and climate change. That said, as you see on this slide, there are quite a few international fora where these discussions could be advanced. And some may be more or less familiar to climate experts or to human rights experts, such as the International Seabed Authority, or the processes under the UN Food and Agriculture Organization on small-scale fishers, or the current UN Decade of Ocean Science for Sustainable Development. So this is just to give you a sense of where I see gaps or areas where we need further thinking in terms of connecting human rights with the ocean. And I think each and every one of them is relevant for our own thinking on climate change and human rights. First of all, we're really just starting to understand the full importance of procedural rights in the context of very technically specific decision-making processes that concern the ocean, such as marine spatial planning. And also processes that are still not so much on the radar of, say, human rights practitioners and scholars, such as discussions on the blue economy. And so very recently I was involved in UN consultations on environmental human rights defenders, and it was very clear that there as well, our understanding is really focused on land defenders, and there was very little awareness of how much small-scale fishers, coastal communities, protesting against, say, offshore oil and gas exploration or other human ocean exploitation activities may actually be also environmental human rights defenders. And often their causes may be very much aligned, if not already joined up with climate change activists. Linked to what we were discussing before and the several ecosystem services that the ocean provide to us, of course, all our own human rights to health, food, water, and culture are related to the ocean, but there's still limited understanding international practice in that area, and what that means if we take into account climate change specific threats remains to be discussed. I think the role of particular human rights holders and what it means for their engagement with climate change also remains to be clarified. We've made more, maybe there's more clarity in relation to indigenous peoples' human rights in the context of the ocean and climate change. But in as far as rural women are concerned or children are concerned, I think the awareness both on climate change experts and human rights experts of what ocean decision makings and more generally ocean science are relevant remains to be advanced. And with that, of course, then the implications in our related conversation on business and human rights, on the regulation of foreign investments, and more broadly also international cooperation on human rights. So while the start of this presentation has been about gaps and maybe missed linkages that we still need to clarify, what I would like to offer for discussion is that in my own work on analyzing international biodiversity law, and particularly the decisions that have been adopted intergovernmentally under the Convention on Biological Diversity, we have already built quite a few bridges to understand the nexus and to understand what governments and state actors more generally are expected to do. And while often under the Convention on Biological Diversity, we do not speak explicitly about human rights, I think several of the guidance developed under that framework is relevant for us to consider also human rights, even if not in explicit terms. And some of the case law from the Inter-American Court of Human Rights has demonstrated that instruments adopted under the CBD can very well be aligned and be helpful to interpret international human rights law, particularly in terms of practical steps and approaches and benchmarks for assessing the conduct of duty bearers, in particular natural resource development contexts. So starting from John's work and his annual report on human rights and biodiversity in 2017, I think that's really where a fuller understanding of the actual and potential role of international biodiversity law to both contribute to the protection of human rights, but also to be interpreted in more explicit human rights terms, really came to the fore. And I think particularly this was an issue that I think both in maybe international human rights fora and international biodiversity fora was very much left unclear in legal terms. And it's really been, I think, John's report that has helped to dot the I's and cross the T's in terms of the extent to which international biodiversity law matters also for the international obligations of states in terms of human rights law. And particularly this obligation to find a reasonable balance between the protection of biodiversity and other legitimate societal goals, the need to prevent unjustifiable and foreseeable infringements of human rights who may be dependent on biodiversity, including in the case of planned climate change response measures and renewables development. So there was a clear, I think, capturing in this report of how we had already accrued evidence of climate change response measures and renewables development that had both human and negative impacts on human rights and on biodiversity, and how we needed to really read obligations arising from these three areas of international law in a more mutually supportive way. We had a more recent report in 2020 by the current Special Rapporteur, David Boyd, where I think he not only elaborated on these points, but he also pointed out how we have international negotiations where these issues should be taken into account. And I think it was really interesting and quite bold of the rapporteur to mention the current UN negotiations on a new internationally legally binding instrument on marine biodiversity of areas beyond national jurisdiction, as one negotiation where we should talk about human rights. And to me, that's really essential, because one issue that's been discussed in those negotiations is whether and how we should carry out strategic environmental assessments in the context of the high seas and the international seabed. And that's really where real consideration of climate change impacts would be included in that agreement. So I think that there's an important opportunity there, and it's good that it has been picked up by the rapporteur, but there's a lot of, I think, awareness raising, and again, legal thinking and collaboration with science to really advance that recommendation in practice. So just to say that in my own work, what I've been trying to understand and assess is the degree to which CBD parties have been able to identify in a timely manner or in a systematic manner potential and actual threats arising not only from climate change itself, but from our responses to climate change, to the conservation and sustainable use of biodiversity, very much relying on the CBD obligation, which is quite open-ended, to assess and prevent negative impacts on biodiversity. And through this kind stream of work, the CBD Conference of Parties has been able to adopt by consensus by 196 parties a series of guidance documents that have clarified, at least in my own reading, the obligations of CBD parties in relation to climate change, but also human rights. Again, that's done maybe in an implicit way, and either directly or indirectly referring also to ocean management. This has been very much shaped by the ecosystem approach of the convention, so taking a holistic approach both to the environment, but also to humans and culture as part of the environment. And as I said, without using human rights terms necessary, but looking at specific issues that have human rights relevance, particularly but not exclusively those of indigenous peoples and local communities. And so this is just to give an example of some of the guidance that has come up and that help us to see international law evidence of that understanding of the nexus that I was alluding in my title under the Convention on Biological Diversity. Looking at the importance of the ecosystem approach with a view to tackling what we have as an aspiration and interpretative guidance in the preamble to the Paris Agreement, understanding the importance of integrity and functionality of all ecosystems, including the ocean, but also considering the questions around people's reliance, taking into account social, economic, and cultural co-benefits. And that's one of the entry points for reading the CBD agreed language in human rights terms, for instance. And we often have then more specific recommendations related to indigenous peoples and other local communities, such as, for instance, recognition of their own conserved areas and their own biodiversity-based livelihoods in climate change decision-making. I won't go into all the details of this guidance, but I was really keen to just show the extent to which the nexus between climate change and biodiversity has been addressed under the CBD, and also where we have specific indications of how we can address that, what kind of terms have been used under the CBD to refer to questions that, in my mind, are very much human rights issues. And for those CBD parties who are parties to the relevant international human rights treaties, need to be interpreted and understood as guidance to interpret their own international human rights law obligations. So questions related to transparency, to looking into inequities, to the protection of knowledge, to the assessment, not just of environmental impacts, but also sociocultural ones, through, for instance, the CBD Aquecon guidelines that have time and again been recognized by international human rights bodies as a really helpful and almost paradigmatic guide for states to really take into account and be thorough in cooperation with indigenous peoples and local communities, taking into account potential impacts on their lands and resources. Questions of tenure and livelihoods and gender equality and human health have been raised across the board of more general CBD guidelines, say on ecosystem-based adaptation, for instance. And we also find them in more specific guidance related to socio-ecological resilience, which in this case did focus on particular marine ecosystems such as coral reefs, mangroves, and seagrass. So as I said, I won't go into the details of this, but it was really just to, on the one hand, I think show that for how much governments in the context of the climate change regime are still starting to discuss the importance of the ocean in as far as the international climate change regime is concerned. They have addressed specific aspects of that connection in some detail for years under the Convention on Biological Diversity. And in that context, they have been able to address that also from certain human rights perspective, even if they're not doing this using explicitly human rights terminology. And this is relevant because it shows that we're not starting from scratch in looking at this nexus and in understanding that there are ways, both principled but also very practical, to read together international obligations under international human rights treaties, the international climate change regime, and the Convention on Biological Diversity, that point at the expected behavior of states and the modalities to implement all these obligations that have been developed in isolation and yet are very much dependent one on the other in specific contexts. And I want to conclude just to make a bridge with the presentation that will follow mine, to say that for how much we have quite a lot, and it will be important to discuss to what extent the CBD guidance is helpful practically, to what extent it is clear from a legal perspective. It's also important to show that it has advanced, I think, understanding mainly from the perspective of the rights of indigenous peoples and local communities. And even there, CBD parties or some CBD parties do have quite divergent interpretations of the terminology and the approaches and the status of international human rights law in that context. But I think there are also important human rights holders who still yet have to receive sufficient attention under the Convention on Biological Diversity. That is the case of women, but I think it's particularly the case of children. And we have ongoing negotiations at the moment under the Convention on Biological Diversity, particularly in the context of developing a post-2020 global biodiversity framework, where one of the key questions is to what extent CBD parties should engage more explicitly with human rights and take more seriously advance international cooperation related to intergenerational equity. So lots of pushes from civil society in terms of more fully embracing an explicit human rights terminology in the context of the convention. But I think that these questions of understanding the relevance, in particular, of children's human rights in the nexus of biodiversity and climate change, and for my own purposes also for the ocean, is really crucial elsewhere, including in all those ocean-related negotiations I mentioned at the beginning, but also ongoing processes in international human rights for all, and particularly the development of a new comment on the human rights of the child to a healthy environment with a specific focus on climate change. And so this is just to share a few thoughts around how important it is that we don't forget the ocean in the development of this general comment on children's human rights to a healthy environment with specific reference to climate change, how those very rights that we know are imperiled by climate change may be so also because of how we are not sufficiently tackling climate change through our ocean-related decision-making and management, and for how much we're falling short in addressing climate change impacts on the ocean, be that related to sea level rise and disaster risk reduction, but be that also related to, for instance, access to fisheries and the importance of that for the right to food. And so I think one of the interesting questions in advancing that thinking, be that under the CBD or elsewhere, is how important it is now that we see the role of children in climate litigation and international climate change diplomacy. How can that incredible development be related also to decisions on the ocean, that at the national level as well as the international level? And for that to become a reality, what kind of information we need to bring to children for them to be aware of the role of the ocean vis-a-vis climate change and the importance of the ocean for their human rights. And how do we then build processes, particularly such as those of marine spatial planning, environmental impact assessment, and strategic environmental assessments, where the best interests of the child are truly taken into account and can help us think through the implications of that nexus between biodiversity, climate change, and the ocean from their perspective. Their longer term perspective may be that of older members of society. And also thinking about ocean defenders as including children and youth environmental human rights defenders, what risks might arise there and what support may be needed for them. And so to realize, I think to really support children's rights, to participate effectively in those decisions, we do need to look about education, the role, the extent to which the ocean is included in understanding of the importance of the environment and climate change for children's rights, but also children's input into science. As I said, we are at the start of the young decade of ocean science. And it'll be really important to understand how children can have a voice in that process, help to set priorities, and become themselves part of those international processes. And without going into further detail, just think through what are the other areas of that nexus between human rights, climate change, biodiversity, and the ocean that have to do specifically with children's human rights. So I'll stop here, and I hope this was enough to have an interesting conversation about these issues, whether or not your own research and interests have focused on the ocean so far or not.
Thanks. Thanks, Elisa. Now we can open the floor to the discussion. Are you suggesting me? Can do without this. Who is going to break the ice or to raise the first question? Yeah, okay. I was almost sure that Karin was going to ask a question, but I wasn't to put any pressure on you. So please, Karin. She's coming to the microphone.
So yes, Elisa, thank you very much. This is Karin Arts. But to your surprise, perhaps, I'm not going to ask a question about children, but I'm going to ask a question about whether we should also think of climate change and climate change policies in a broader generational perspective. Because although I will make, I hope, vivid plea for child rights-based climate change policies later on, I think there is also a big need, for example, for looking particularly after the needs and rights of elderly. And thinking back to the thought that John Knox earlier on shared with us about how difficult it might be for treaty bodies to reach out to powers like Russia or China, if we manage to connect to concerns that are especially important for those countries, and China has a very clear policy on rights of the elderly and also on the right of development, that could maybe help us to make some headway. So I would be interested in hearing your thoughts on that.
Shall I take one question at a time?
Yes, that would be better. Yes, please.
Yeah. No, thank you so much. And Karin, for sure, I'm looking forward to learning from you about children's rights. It's just a new area of interest for me. And yeah, I look forward to hearing your presentation. But I think your point is really interesting. And I was referring to children's rights just to give an example of once we take one particular area, maybe of international human rights into account, we see how many follow-up questions arise in really thinking through that connection with the ocean. But I think the point about generational perspective and more generally, how do we bring on board all human rights holders and all states who may or may not have similar interest or understanding of international human rights law is really important. And I do think that trying to engage with as broadly and as a fine-grained human rights lens in this conversation is really interesting. I must confess that I haven't quite thought about how the human rights of the elderly could come into play in this connection. But one thing that has been on my mind for a while, and I still need, I think, to develop the thinking there, is just more generally how everyone's right to health is really at stake here, and how particularly the scientific evidence from the health community might be a really powerful, hopefully, a really powerful motivator for different sectors of society whose health might be more at risk to engage in this debate, and for us as lawyers to develop the understanding, a deeper understanding of state obligations, particularly in the context of evolving science on the role of the ocean vis-a-vis climate change and how that may affect our health today and in the near future. So maybe that could be one interesting direction for research and policy engagement.
Okay, many thanks. We have a question from Emanuele, please. And also myself, Emanuele.
Elisa, thank you very much for your presentation. Again, very, very thought-provoking. I have more of a, how do you say, a systemic question, in the sense that I understand and I appreciate very much the fact that, as you were rightly stressing, different branches of international law must, so to say, compenetrate each other and influence each other. My fear, though, is that when Ministry of Foreign Affairs were negotiating all these treaties, they were not thinking of the other commitments under other branches of international law that they're already taken. So my question is, if we stress this, and it's basically a very provocative question, of course, if we stress this need for interaction, this anti-fragmentation sentiment, if you wish, too much, are we not running the risk of let's say, having an opposite reaction by states, saying the states will in the future sort of try and avoid take legal undertakings in different branches because they might be afraid that, you know, through the influence of other branches of international law, their obligation might all of a sudden be, you know, transformed into something they didn't have in mind when they signed up to these treaties. I don't know whether I made myself clear, or it's more of a, so do you see the risk of pushing this interconnectedness between different human rights, different legal branches too much a bit, or is it just my impression? Thank you.
Yeah, no, I think it is true that once we take that mutual supportiveness lens to interpretation across different international regimes, we can end up with results that are very far from the original intent and expectations related to the subject matter of each individual treaty. And yet this is a very, I think, I think it is hard from a purely legal perspective to object. Many international treaties are living instruments. Our own scientific understanding evolves over time, and so matters that at a certain point in time we felt were separate issues may, our understanding of their interconnections may change. So I think there's both like legal and scientific reasons why our understanding of international obligations need to evolve. Whether that may dissuade governments from developing new international obligations, I don't know if from developing new, or whether trying to, I think maybe what I see in international negotiations at the moment is states being very narrow in how they develop new instruments and maybe unambitious in as far as maybe the environment is concerned. But I think, as John was stressing in his presentation and in his work, that is not necessarily a very big concern because we have so much existing international obligations already to really, once read together, to really clarify where the conduct of state, which level, what kind of content we expect of the conduct of states. So while we still have international negotiations that are important, and I think that the BBNJ ones have mentioned are really important, and it is a shame that at the moment the level of ambition in the negotiations is not sufficient for sure to address the challenges we're facing and the urgency of those challenges. We have so much existing international law that governments should rather focus their efforts on seeing what that means for them already. And so the concern about future obligation, the development of future international law, I think, while important for some specific areas, is not so. It's not, I think, a concern for me of such significance to prevent making these arguments about interpretation. And I think maybe what is important in terms of getting the buy-in for governments, and I think this is where, in a way, the CBD might thread on interesting ground, is not taking so much a very legalistic approach. And this is why, in some ways, maybe we don't have the very explicit engagement with international human rights law yet that many right holders and civil society may wish, is really to try and focus on what is a practically helpful approach to read those international obligations together, to really look at how, even if those international treaties were negotiated in isolation and continue to be implemented by experts that maybe work in isolation from each other, it is possible, in addition to it being desirable, if not necessary, for those obligations to be implemented in a mutually supportive manner. And in fact, they're important savings, they're important pooling of resources, they're important opportunities for having a more streamlined work if we do read them together. And so some of the more practical guidance that has been adopted under the CBD is very much about, in a way, making the work of governments and other duty bearers easier, in showing how these obligations can come together and identifying tools that can support governments in thinking through all these implications that in real life are interlinked, whether we thought about them when we concluded those treaties or not. And so I think that and thinking around capacity building issues around the understanding and implementation in a coherent manner of these disparate obligations is really maybe what may matter the most for governments, whether or not they may be even party to relevant treaties. So the kind of arguments which is, maybe solid from a legal perspective, but is really focused on giving helpful advice for coherent implementation, might go a much longer way than a more law-focused argument with governments. And hopefully might then show the value of being more holistic in developing new treaties in the future.
Okay, many thanks. There is time perhaps for a couple of questions more, one of which I'd like to raise myself. I'm not at all an expert, okay? So please forgive me if I say some stupid things, but I have an impression, or I had an impression when I was listening to your presentation, which is the following. The impression is that in the responses that have been provided by single and political orders, especially major states and other strong polities or political orders, I see a sort of reluctance to engage properly in the protection of the biodiversity of ocean. Now, I don't know if it's true or not, but I have had this impression when I was listening to you, and I was wondering why this impression is correct, why it is so. And I have two guesses. One is that perhaps biodiversity is such a difficult subject, the kind of responses that the polities have to provide to climate change. And it is a very difficult subject, a very sensitive subject, because it has a very peculiar aspect, which is the following. It tends to come to conflict with trade, with freedoms, economic freedoms. It tends to be different from the traditional way in which environmental protection is ensured within the market itself. So biodiversity is potentially more complicated to manage than traditional environmental protection. And the second guess that I put on the table is the following. Perhaps there's also a problem when we apply biodiversity to ocean. So when we consider ocean, because the reaction, the responses to climate change tend to concentrate, they tend to focus to problems which are internal to the polities, internal to the legal and the political orders. For example, of course, they consider water, the different types of water, but they are lakes, they are seas, they're not oceans. Oceans are perhaps something which are perceived as external to the boundaries of the single polities. So I was wondering, first of all, I was wondering whether this is a correct impression and perhaps a correct way to address this impression, or if simply have to explain me from zero your argument because I lost something and some key passages. And a second question, more brief, is the following. Is there a specific role for the European Union in this global action to protect the biodiversity of oceans? Thank you.
Yeah, no, thank you very much. I think your intuitions are correct. I think it's true that certainly when we talk about biodiversity, we're not yet at the global levels, I think, of awareness, of urgency, and I guess maybe an emergency that we have in the case of climate change, even if maybe our global experience of the COVID-19 pandemic may have slightly changed perspectives, but I still wonder to what extent policymakers and also citizens around the world are aware of the biodiversity dimensions of the global pandemic. But I do think that there's always, I think, more reluctance in discussing biodiversity conservation and sustainable use than there is to discuss climate change. And maybe the fact that there is more understanding that the two challenges are intertwined is helping the biodiversity cause, so to say, because on its own, international biodiversity cooperation has struggled to get the same level of political attention and understanding as climate change has. Why that is so? I think that there's many different reasons, but maybe it is true that kind of in terms of nature protection in classical terms and you know, biodiversity more generally as a more maybe holistic approach to nature protection, the tensions, if not the trade-offs in terms of economic development and basically natural resource development choices are maybe more obvious, and they appear more somehow more threatening to our current approaches, even if, as we said, you know, today at the start of this session, the changes we need from a climate change perspective are as systemic and drastic as the changes we need from a biodiversity perspective. But I think that understanding of the change needed from a climate change perspective is still to seep in, whereas we know from almost daily experience that the changes we need from a biodiversity perspective are those painful changes to our economic models, which most governments and maybe sectors of societies are not ready to make. In terms of marine biodiversity in particular, I think there's an additional element, which is that because our science, our scientific understanding of marine biodiversity is still advancing, we do not have the full appreciation of the value of marine biodiversity for, say, be that climate change mitigation and adaptation, but also for global health or global food security. And so not only we're part of the broader issue of the evaluation of biodiversity in broader decision-making, but we have even a deeper problem because we just do not know enough about, we don't even know what marine biodiversity there is out there in the depth of the seas, let alone what it does to us in terms of oxygen production or opportunities for global health or global food security or addressing climate change. I'm not sure if I understood the second part of the first question. I mean, definitely when we consider the oceans, we have maybe more complicated understanding of legal rules applying to areas within and beyond national jurisdiction, and certainly both from a, again, scientific perspective and legal perspective, one issue that remains really to be fully explored is the connectivity among the activities and the life that we have in the oceans in different parts of the ocean that legally are divided one from the other in terms of powers and obligations of states. And so we often see that in the negotiations at the UN on BBNJ, where we don't really consider enough impacts and for impacts of activities in areas beyond national jurisdiction for marine areas within and local populations who may be dependent on those marine areas. So that there's definitely more complexity there maybe than in other areas of environmental protection, although I think that in the climate change negotiations, we have other tricky questions related to areas within and beyond national jurisdiction. And finally, on the question on the role of the EU, I think that's a really interesting one and one on which I happen to have some direct conversations with the European Parliament and the European External Action Service. Earlier last year, the European Parliament commissioned a study on the relationship between human rights and biodiversity, with a view to then understanding what action the EU should take externally to contribute on the, following on already an existing portfolio of activities related to climate change and human rights. And it was quite interesting to see how many aspects were kind of left behind because climate change and human rights were looked in isolation from the relevance also of biodiversity and, say, toxics, so other areas of environmental law. And there are many opportunities for the European Union to contribute, be that in terms of negotiating positions in different UN fora and, of course, use of funding through multilateral institutions. But I think even more equally interestingly in the context of unilateral and bilateral external measures. So, for instance, the work that the European Union does in terms of protecting environmental human rights defenders, and through that really giving attention and resources to ocean and biodiversity defenders, which I understand is quite a new area where the EU needs to equip itself to really make a contribution. Another area where the EU has been active, but maybe more selectively, is the use of bilateral trade and investment agreements and the use of bilateral funding to address biodiversity and human rights issues. So it has done so in some selected areas related to forest governance and illegal, unreported and unregulated fishing. But there is a much broader set of issues that the EU could tackle. And again, really assessing whether a more holistic approach would make much of a difference than building on the lessons that are really important that have been learned in those more targeted area of intervention that they have already explored.
Okay, many thanks once again, Elisa. And I think we can now move from to the third and last presentation, which will be given by Professor Karin Arzt. You already heard her voice, but just let me say that Karin is Professor of International Law and Development at the Erasmus University of Rotterdam. Her research work focuses on a number of fields, including the role of international law as an instrument of change, as an instrument of transformation, and in particular as an instrument of change in order to realize equitable development, a right development, and also she works on in the field on the implications, on the contents and implications of human rights-based approaches to development. So she's going to give a presentation on the justifications and implications of a child-raised, child rights-based approach to climate change. Please, Karin, you can decide where you can sit, whether you want to use the microphone or you want to hear the microphone. Charged. Should be there, so don't be worried. Sai lanciare.
So, thank you very much. First of all, I want to thank the organizers for inviting me. In fact, I'm really excited because it's my first, at least partly in-person conference, but also my first conference trip since 1.5 years. And I'm glad that this is possible again. I was asked to speak about a child rights-based approach to climate change. And while a lot has been said already about the topic, I think I can still stick to the outline of my presentation by filling in just a bit more detail of a number of aspects that relate to this topic. Something about the evidence, which is part of the justifications for actually pleading for specific attention for children and children's rights in climate policies, but also in climate lawmaking and implementation. Why specifically, so not only why a focus on children, but also why a child rights-based approach. What is the role of the Convention on the Rights of the Child? What are the implications of all of this in terms of actual practice? And I will illustrate that with a few concrete examples, also of legal mobilization efforts that are taking place in so many countries and fora all over the world now. One general remark that I still would like to make is that, well, I don't know how it is for you or how it is here in Italy, but in my own country, the Netherlands, a lot of people, certainly in the general public, still have the idea that climate change is a problem of the future and of future generations. And that is also the connection that people often intuitively make between children and climate, to say, oh, sure, children are the future generations, so we need to connect these two issues. But I find it very important to really stress strongly that climate change is here and now. And probably everybody taking part in this seminar knows that, but there are a lot of people who don't know that yet. The pictures that are here are of different parts in the world, of a small island state in the Caribbean, Trinidad, people wading through the water in Port of Spain, the capital of the island. The first speaker this morning, this afternoon already said that climate change brings about extreme weather patterns and incidents. So climate change is not only about flooding and excessive water, but it's also about drought. And that is what the other picture of a country in Asia, and it's either Indonesia or the Philippines, portrays. The picture at the bottom I included because in my own country, the Netherlands, until recently, people also thought a lot, you know, climate change, yes, that's a problem for developing countries in the south. Here in the Netherlands, and especially a country that is so well known for its water management, we can manage. But this picture dates back only, well, is it 6 or 7 weeks ago? And it shows a neighbor who rescues his 101-year-old neighbor, the woman that he is carrying, because of a very unexpected but very serious flooding that happened in the south of the country, and that was directly linked to climate change issues. And that now has brought home the message to a much broader part of the general public, and I think that is important. I do not need to say anything more, I think, after everything that was shared already by the other presenters about the scientific base, including, very importantly, the most recent climate change physical science basis report of the IPCC. But I do think it's maybe good to also add a few more facts that explain maybe part of why it is so difficult to make more headway and to realize faster achievements in terms of climate change law and climate change policies at the global level. And this is a part of what UNICEF, the United Nations Children's Fund, in a recent report of August this year, "The Climate Crisis is a Child Rights Crisis," is the title, puts forward in terms of what we know about the, you could say in a sense, the division of the responsibility for causing the problem and the misfortune perhaps of being most severely affected by the problem. And there UNICEF presents this as follows: 33 extremely high risk countries collectively emit only 9% of global CO2 emissions. And the 10 highest emitters together are responsible for 70% of global emissions. And of those big emitters, only one is at extremely high climate change risk, and that is India. If I then shift to putting a bit more detail to what I see as justifications for taking a child rights-based approach to climate change, then we have heard already a lot in general terms about the influence of climate change on the lives of people now and in the future. It is about health problems, it's about natural disasters, it's also about psychological effects of these extreme weather events, including natural disasters. It's about displacement, and it was already, of course, referred to in some of the cases that John mentioned about migration. consequences for people's livelihood, access to water, but also certainly in scenarios of severe drought, impossibilities for local populations, for example, to meet their subsistence needs by growing food crops. And specifically for children, perhaps the issue of lesser possibilities for outdoor play. And then people might say, that's a fairly trivial example to give, but actually for children, the right to play is extremely important in order for them to fully develop themselves physically and mentally. Now, children, why specific attention for children? As earlier on, I referred to another example of a group that is in need of special care and attention, and that is the elderly. And in scenarios of, for example, very warm weather, we know that the elderly are at big risk of suffering all sorts of health consequences. My argument is that, well, I do not plead for children to the exclusion of others, but I do think it is important to bring home much more strongly than has been the case so far, that children require special attention. And because the Convention on the Rights of the Child is nearly universally ratified, all states in the world are a party to it except for the United States of America, that poses particular obligations on states. And simply, if we look at the figures of the part of the population that children and youth make up for, I think that serves my argument. The group of children in the age of 0 to 18 make up 30% of the world's population at large. And youth, and that is then the group of between 10 and 24, 25%, so a quarter. In many countries, especially in the South, children, and certainly children and youth combined, make up the majority of the population. So that in itself is already a very strong argument for law and policy in the field of climate change, but also in other areas, to actually sufficiently consider the needs, the rights, and the impacts on children. Then children are disproportionately affected by climate change. And that's a strong word, disproportionately affected. But there is a lot of evidence that underpins the claim. Children, because of the fact, for example, that they are physically not yet fully developed, stand a much bigger risk of health effects on average than adults do. For example, the impact of air pollution on a child, or the impact of diseases that are caused, all sorts of waterborne diseases that are caused by, or at least that become more prevalent because of climate change, affect children more than adults. There is also the aspect of the double impact. We are affecting children now, but we are also affecting children in the future. And climate change is affecting children now and in the future. And that is why in the literature you find the argument being made of double jeopardy or the double impact. In another way, children are also often more vulnerable. When we think of children, how children fare in extreme situations like natural disasters or floodings, very often there too, children clearly are more vulnerable. For example, if you look at the figures of drownings in floodings, well, children there feature significantly higher than other groups of the population, although they do so quite often in many settings together with women. Children in developing countries and or children living in poverty. Children living in poverty we have everywhere in the world, not only in the South, but also in the North. And women, indigenous and other vulnerable people, such as people with disabilities, are also especially affected. So that would be adding another layer of extra vulnerability for children that well, could be characterized in these terms. UNICEF is one of the actors, but not the only one. It's one of the actors that has brought together quite a bit of evidence on all of these issues. And here in the slide, you'll just see a reference to two important reports, one dating of 2014 and the more recent one that I mentioned already, The Climate Crisis is a Child Rights Crisis. But these facts are known for a long time. And I think I would say, in terms of the evidence base, actually we know more than enough, and it's really high time to act. At the same time, as already was concluded also by other speakers or noted by other speakers, in actual fact that is not happening yet. And earlier on, there was already reference to the Paris Agreement and to the fact that states there are supposed to formulate nationally determined contributions in which they indicate sort of their plans and their targets in terms of curbing climate change. And it's interesting to note that only 42% of those NDCs that have been published so far refer in very broad terms to children and youth, or the younger part of the population. Only 20%, so that is 1/5, mention children directly. 23% do not refer to children or youth at all. And only 3 countries mention children's rights specifically. So on the whole, I would say, certainly in light of what I noted before, of children and young people making up such a large part of the world population, that actually falls short quite a bit. Now, if we look at this matter, perhaps in a yet more legal perspective, and also somewhat more technical legal perspective, then there are also interesting legal facts to add. And the first point that I'm making here already came up in the discussion as well. But it's an interesting legal fact that all, and actually I noted this morning that the figures that are on this slide are not entirely up to date. It's 197 states that are parties to the Framework Convention on Climate Change, and 191 state parties to the Paris Agreement. All of these also ratified the UN Convention on the Rights of the Child. And even though, as happened already in the earlier discussion, one might place some question marks about, to what extent in these legal instruments should be interpreted in connection to each other or should be integrated, I think the question definitely comes to the table, especially in light of the fact that climate change clearly jeopardizes the realization of a large part of the Convention on the Rights of the Child. And in light of the fact that Article 4 of the Convention on the Rights of the Child was actually, which is the main article laying out the implementation obligations of states parties under the Convention, was formulated in a very generic manner, and that was done on purpose. It was done on purpose to make sure that the article would indeed cover also sort of future threats and risks to children's rights that perhaps were not yet known at the time the convention was drafted in 1989. Article 4 says, states parties shall undertake all appropriate legislative, administrative and other measures for the implementation of the rights recognized in this convention. So that means states have to do all it takes. And if it then is so that climate change jeopardizes directly a huge part of the convention, then that means that climate change action is required, not only based on climate change law, but also based on human rights law, in this case, the Convention on the Rights of the Child. For those of you who would be interested in exploring in more detail the exact...
Sorry, may I interrupt you? It seems that we have a problem with the PowerPoint presentation. because it's visible here in the room, but it's not visible from home. It seems to be stopped at the first slide. So we are really sorry because we got the message only now. Just 1 second to try to find a technical solution. Sorry, I apologize. We didn't realize that. What do you see now? Please don't write on the chat because we can't see the chat now. Please hear from the desk.
Yes, we can see it right now, Professor.
Okay, many thanks. Apologies again.
Okay, I'm sorry about that, but I hope that also without the pictures and the slides, you could manage to have, of course, for the people who are not in the room, you could manage to follow the flow of my presentation. There are a number of, and actually quite a lot, provisions in the Convention on the Rights of the Child that are directly at risk or of not being fulfilled as a consequence of climate change. The right to life, as already was mentioned before in Article 6, obviously right to health care, but, and including right to healthy and nutritious food and water, an adequate standard of living, education, certainly in many scenarios of, for example, natural disasters, education becomes interrupted quite a bit. And that has sometimes really serious implications, especially if the interruptions last long, as we have all seen in the last 1.5 years, as a consequence of COVID-related lockdowns. The right to enjoy one's own culture and language and religion also has to do with that. For example, in situations of massive displacement of people, these rights may come at risk. I already referred to the right to play, the right to non-discrimination, where perhaps that will come up in scenarios where only certain groups may have access to protective measures or strategies. And as there is a lot of evidence nowadays to show also in situations of either natural disasters or sudden or not so sudden massive displacements of people, the right to family life, or the right to not to be exploited or abused economically or sexually, or not to be abducted, sold, or trafficked, may be at risk. And it's well known that in these types of scenarios, there are, for example, human traffickers who look out for unaccompanied children in order for them to be trafficked. So a quite vast picture, I would say, of rights included in the convention that are potentially and in many places actually already are at risk. So my argument would then be both based on climate law, but definitely also based on human rights law, and more specifically the Convention on the Rights of the Child. Climate action is mandatory. That action has to be child rights based, and that means that in the measures that governments are taking, for example, the general principles of the Convention on the Rights of the Child will also need to find a place. And that means a focus on issues relating to survival and development, as included in Article 6, non-discriminatory, both in orientation and in implementation of measures, Article 2, the best interest of the child should be a primary consideration, and participation or involvement of children, where appropriate and possible, should also be looked after. And I think in light of what I said before of, well, the disproportionate effects on children but also children being affected both now and in the future requires us to be more serious about also listening to children and giving children and youth a voice in how to tackle these problems. And sometimes that may sound very complicated or difficult to do, but in many instances, actually listening to children is a very good way of also coming to new ideas and of actually realizing in the first place how climate change related effects change children's lives and what could be done to tackle that. And I'll give you an example of that in a minute. It was already stated before, but also for children goes that attention for the most vulnerable is mandatory. That is a clear message that comes out of the human rights framework at large, but also out of the Convention on the Rights of the Child, with specific articles for children with disabilities, for migrant children, and for a number of other specific. Now, what then does that mean in terms of what governments need to do? I already mentioned legislation, I mentioned policies, but there are other things that are, well, maybe equally important as well. And first of all, that has to do with further specifying and deepening the evidence base that we have. By gathering more information about the specific effects of climate change on children. And there, I think it's really interesting that this August 2021 climate change report by UNICEF, for example, introduces a climate change risk index related specifically to the situation of children. But of course, then, yeah, not just gathering information for the sake of gathering information, but analyzing that information and considering it in all relevant decision making. Striving for structural solutions. That is another key message that comes out of the human rights framework, which then means that actually the first priority should be mitigation. So trying to curb climate change so that damage will be prevented rather than occurring. And in second instance, of course, adaptation, helping all of us, including children and their caretakers, to live with the consequences of climate change. Now, all this reasoning has become the basis for what I see as a very interesting and also dynamic current practice of various forms and using various means of child-focused or child rights-based climate action. And one example of, well, maybe a rather simplistic example, but still, I think a good example of how in a very sort of local, down-to-earth way, one can make a difference by listening to children, is this booklet of Holistic Child Development India, already published in 2009. This is a child-focused development NGO who actually took it upon themselves to collect the voices of children about how climate change affects their daily lives. And by publishing the testimonials, you could say, of these children, the local community became much more aware of what this actually means for children and what would be lines along which perhaps some of these consequences could be mitigated or lifted altogether. So here is just an example of a 12-year-old boy who says, in persistent rain, excessive water makes the clayey soil slippery. Often we slip and fall on the way to school or the house. Sometimes we don't go to school because if you slip and your clothes become dirty, you're not allowed to enter the school in this particular environment. Teachers don't come in the heavy rain and the government gives a rain holiday. And actually, in a later account, more children were saying, we don't like those rain holidays at all. As much as possible, we want to continue our education and we want interruptions to be as brief as is necessary. And this ran very much counter to what a lot of adults in that community were thinking. They were thinking that children were happy with a rain holiday. Okay, a simplistic example maybe, but also an example which shows that it is important to listen to children, because they bring up issues that adults may not even be aware about, and they may also bring up issues that actually a local community can act upon. Okay, I think in view of the time, I can leave these the other examples that are here of research being conducted. And here is the picture with the full title page of the most recent UNICEF study that you may want to look up if you're interested in that. We already discussed, of course, the importance of regulation, not only inserting environmental concerns into human rights law, but also the other way around, of integrating or finding ways to bring in human rights concerns more into environmental law, including climate change law. And we have the specification of how that was done but only in the preamble of the Paris Agreement, and not in the agreement proper. I think John Knox already said quite a bit about the role of human rights treaty bodies. And he made the point already that the CRC committee is perhaps one of the forerunners in this field. But I should say, if you look at what that then means in terms of actual practice, it is still quite modest. Concluding observations, I look at them from year to year, and I find still no logic in why it is that in concluding observations for certain countries, climate change is explicitly mentioned, but it can still happen for there to be small island states for which climate change is not even brought up as a concern at all. So I think there's a lot to be done still for that, for the committee to address these issues more systematically and consistently. At the same time, it's also clear that COVID-19 has affected the work of the treaty bodies also a lot. In the last 1.5 years, the CRC committee has hardly been able to pass any concluding observations at all. That is picking up again. And that is highly necessary. Now, sort of the last sphere of practice examples that I would like to refer to is also already mentioned by various speakers, and that is legal mobilization or strategic litigation, as it is also often referred to, judicial interventions at all kinds of levels, international, regional, but also really importantly, and again, speaking of sort of more, maybe more down to earth and practical level, at the national level. And the picture that you see here is a case which says gewonnen or won. And then at the bottom, kabinet aan zet, which means it's your turn now, government. This is a picture of agenda case in the Netherlands. Which I think is internationally known quite a bit, where on the basis of, among others, the right to life in the European Convention on Human Rights, a court case was brought and won, forcing governments to stick to, its own promises in terms of the reduction of CO2 by 2030. And what is interesting, I would say, about the cases, and that is probably regardless even as to whether a case is won or lost, is that these cases have turned out to be really important tools for awareness raising, both nationally but also internationally. The team behind the agenda behind the agenda case has shared a lot of its experience with other actors elsewhere interested in bringing these type of cases. And a lot of those cases are actually happening now. Many of these cases bring up arguments that have to do with children. And they do so partly because of a genuine concern about children being disproportionately affected by climate change, but also because it's strategic to do so. A lot of people sort of intuitively sympathize with children's causes. So then the idea is that it can strategically work to your benefit if you indeed mobilize arguments concerning children, and maybe even better if you have children advocating those arguments. And there are, I think, positives but also risks connected to that. So it's something that we need to look into critically. And a very interesting example is the Juliana versus the US case, where it's a case filed on behalf of 21 young people that all take a very active role in actually bringing the case, but also in spreading information about the case through many constituencies. It's also clear that there are still many obstacles that remain for these kind of cases to succeed. But I would strongly argue that even if in the end they don't succeed in the courtroom, they still can be a success because of all sorts of other achievements that they might have about in terms of information sharing, in terms of awareness raising, etc. On that note, and with an eye on the clock, I think I should end my presentation here. I think on the basis of what I've laid out for you this afternoon, the position emerges that from a child rights perspective, preventing climate change is a first priority. But next to that, the CRC and human rights law at large also provide strong legal arguments for pleading for adaptation measures. We need better data, we need more knowledge, and we definitely need more resources for climate action. And for all of those things, there are hooks, legal hooks in the Convention on the Rights of the Child and other human rights instruments to argue that. So I hope that in that way I have managed to show that pursuing climate justice through a child rights-based approach has a clear added value. But it's also clear that many details still need to be filled in and deepened. And I would say, and the Agenda case is a very good example, but also the Juliana versus US case is a very good example of the people involved in that really trying to mobilize everyone in society as much as possible in playing their part in tackling these important issues. So I would call out to everybody participating in this seminar, including myself, to actually also see where from time to time we can make our own concrete contributions. Thank you very much.
Many thanks, Karin. I think that we can now discussion, comments, reactions, questions, whatever. Reaction, we have about 10 minutes, I think. Questions and the like. Yes, please. Switch on the mic.
Yeah. My name is Christine Bakker. Thank you very much, Professor Arts. I really very much enjoyed your presentation and your insights, and I very inspired again by your insights to look further into those questions on which I've also been working a bit in the past. I was wondering to hear, I fully agree with you that indeed children's rights they're embedded, they're so clearly laid down in the Convention on Rights of the Child. We have national laws protecting children. it is indeed, as you rightly pointed out again earlier in your talk, only one state in the world has not ratified CRC. So it is, we can say it's universally accepted that children's rights are a priority. They are almost, in a way, also a symbol for human rights more generally. And indeed, the point made that it, you know, climate litigation based on children's rights is, in a way, a perspective or a kind of prism for a broader type of rights-based climate litigation, right? It is kind of, if children's rights are violated, human rights are violated as well. So it can indeed be a kind of prism. At that point, very interesting. I was wondering to ask you, I think it has taken so long for, of course, we all know that it has taken too long for states to realize that we need to do something on climate change. So we're still asking ourselves, how is it possible and how can we do something? But why has it taken so long, indeed, also for the CRC, for the committee, for children's NGOs, for children's activist organization to take this potential, indeed, of children's rights to call on governments to do more? As we can see now, and I think that example that was discussed before already, the Saki and others before the Human Rights of the Child, all waiting for the admissibility decision and the ultimate decision, and it may indeed be a catalyst. We really hope it will be. Has it taken so long?
Thank you very much. Why has it taken so long? If I try to answer that question specifically from the perspective of the Convention on the Rights of the Child, then I think the obvious first element is the Convention in itself contains very little reference to environmental issues. There's a reference to water, there's a reference to food, there's a reference to environmental education. But there is no, and anyway, as we all know, I think, in human rights law at large, there is no hard generic recognition of the right of a human right to environment. So that is obviously an enormous obstacle for the committee then to take the matter on and to require states to provide information on that. It's interesting to see, but indeed it has taken a long time, and I think many agree that it was too long. But now the committee in the state reporting procedure, through, by the way, a working group that was only established this year, a CRC committee working group on children and the environment. One of the mandates of that group is to invite states to report aspects relating to children and environment, so that is broader than just climate change, but definitely also includes climate change in their state reports. The second issue is maybe, or the second aspect is what already came up in the discussion earlier about the Sachi case, the case brought by a group of children under the CRC against 5 states parties, and there a major hurdle seems to be admissibility, because as John Knox already said, the children involved have not exhausted domestic remedies. And that is another thing which takes a lot of time. Exhausting domestic remedies takes a lot of time. If you first have to go to the highest judicial instance in your own country, and only after that can you go to an international body, in my case, the CRC committee, that takes time. So that's another factor. And then the whole thinking, but also the evidence base on that links climate change effects to children in particular is only fairly recent. Although if you wanted to see it, frankly, you probably could have seen it quite a long time ago. But the bulk of governments, but also members of treaty bodies apparently have not.
Okay, many thanks. May I take the chance to raise a question? From regulatory point of view, and perhaps with specific reference to industrialized countries, I see the problem, I see the issue of children's rights as part of, let's say, a wider attention that is to be paid the social impact of climate change when we put in relation climate change and children's rights So this perspective is correct. My question is the following. Don't you think that there is the risk to, when we focus specifically on children's rights, to isolate one specific component of a more complex society? And don't you think that in this way we risk to consider children as a sort of, self-sufficient group or set of individuals, perhaps even a culture having its own values, its own beliefs, and its own, perhaps its own tradition also? So don't you see the risk that, don't you think that this might become a problem in addressing the climate change, the social impact of climate change, which is a sort of paradox, but it's not a provocation. It's just to understand your point of view on this. Thank you.
I also don't mean to be provocative, but I would say I could also turn the argument around and say not, as is still the case so often, not considering explicitly the impact on children, denies a reality that is there, and denies a reality that is there for a big part of the populations of many countries in the world. And then, if I approach it sort of through my legal lens of the Convention on the Rights of the Child, I would definitely argue that if states take their commitment to that convention seriously, then they need also heads-on to address this issue, because it is such a major threat to children now and in the future. At the same time, I do very much understand and appreciate your comments, which leads us, or which could lead us in the direction of critically considering what we could maybe mention to be fragmentation in international human rights law, or maybe in international law at large, and that can of course be an issue. And is it then indeed possible, if we come up with all, we could maybe mention 25 specific groups in vulnerable conditions in relation to climate change? At the same time, I would say, purely on the basis of the big numbers that children and young people represent, there's no other way than considering them specifically. But I do not say that to exclude a specific attention to others, but I would maybe use that as an argument for prioritizing certain action over others.
I think we have a last question from Lea, please. She's coming to the microphone.
Many thanks. I was wondering, in light of what we were saying about children litigation being strategic, but also problematic in the sense that it encounters, various, especially procedural hurdles. So I was wondering, how important do you think that litigation is in the case of children compared to other means of mobilization?
I would take that as a question that actually has an even much more broader general importance for all sorts of human rights and children's rights struggles. And I think it's a question that's very hard to answer in general terms, because it really depends on, one, what is the objective that you think you will serve by a court case, but also what is the context you are in, and what is then the likelihood that bringing a court case will have the effects, including the spark of effects, like, you know, mobilizing others, raising awareness, spreading information, that will happen. And I think that's a very strategic choice, which is influenced by so many different factors, not the least also in terms of the law that you will be able to mobilize. If the state you're in is a party to the European Convention on Human Rights, then we know now, because there are some precedents, that that may lead to success. And in other settings, that might be more difficult. At the same time, personally, I find it very encouraging to see that all over the world, ranging from Pakistan to Indonesia to South Africa, to North America, to Europe, we have seen examples of successful cases being brought, and also of many non-successful cases being brought, but cases being brought, which stir up something in society. And that, I think, is, yeah, if that can happen, that's energy used well, I would say.
Okay, I think it's time to close our first session of this workshop. Many thanks to John, to Elisa, and to Karin for their contributions. And many thanks also to the participants here in the room, but also those who have participated from home. I don't know whether Emanuele has some logistic organizational questions to give. Otherwise, yeah, there is something to say.
Yes, I wanted to thank you, Eduardo, for so masterfully chairing this session and juggling between one speaker and the other. And thank you also to the speakers. I only want to say that we will be resuming with a second session tomorrow morning at 8:45. So to those who want to connect, please remember the time. And thank you again so much. And I think we can interrupt now the streaming, and then I will give some details about the dinner tonight once we finished. Okay. Thank you so much again.
Okay. Bye-bye and see you tomorrow morning.